Right, good morning everybody. I'll introduce Elena and Philip and Richard very briefly, just so that we can move on to all the exciting discussion that I know you want to have. So Elena runs the Brown-Rudnick litigation funding practice along with all other aspects of that work in that firm, which has probably grown dramatically over the last few years. And one of the things that's obviously very relevant is how funding has grown into a practice area over the last decade. Philip runs Head of Europe of Burford Capital. Burford doesn't need a great deal of introduction, one of the market leaders in the space. And Richard has run and continues to run the dispute resolution practice of Akin Gump in London. Maybe not called Akin Gump anymore. It shows my age. Akin was the firm that I worked with when I started in litigation funding about 15, 12 years ago, when I ran Elliott's joint venture with Omni Bridgeway in London. And I've been involved in litigation since then. And I've seen a great deal of developments that we can talk about. I mean, I don't want to throw PACCAR into the room if you're not interested in it, but can we just get a sense from you all as to who is actually interested in hearing something about PACCAR and who doesn't know what PACCAR is and just wants to move on? I mean, just give a shout if you're interested in PACCAR, otherwise we'll move on.
There's at least some hands.
Yeah. Okay, well, we'll talk a little bit about it. I mean, it's a decision that, from a funder's perspective anyway, I mean, funders are supposed to make right decisions, and there's a binary outcome in litigation. And unless you were living in a cave and you looked at and watched the Supreme Court hearing in February, I think most funders would have thought that the writing was on the wall and that something was going to go wrong. So I don't think, and I never have assumed, that this was a moment where everybody was suddenly panicking and thinking, oh my goodness, funding's going to come to a halt, because I think most people had considered that there was a real outcome, that there was going to need to be some changes. I don't think many funders, and I'm sure, Philip, you're one of them, are going to be jumping up and down and telling us all now what's going on, you know, in behind the scenes. But I think it would be helpful for us all just to get a feeling as to, you know, whether Nick Rolls-Davies was right to say at the outset, you know, this is absolute, you know, real serious issue. I think he got a lot of criticism early on for saying that, but actually I think the reality is that it is a serious issue and that people have had to consider it. Let's start on a sort of general basis without having to deal with any specifics, but Richard, why don't you kick off and just sort of, how's your practice dealt with it, with funders?
Thanks, Jeremy. So, I mean, it's exactly as you sort of set it up. So, I think there's kind of sophisticated funders that we act for, and Elena acts for as well, had been preparing for this possibility. And I think, you know, if you cast your mind back to when the revised draft DBA regs were published back in 2019, I mean, this point was absolutely front and center in those drafts. So it's kind of been on the table. But it's also true to say that since that judgment came down, you know, there has been a fairly sort of intense period of activity amongst funders, and obviously there are different considerations that apply depending whether you're looking at historic funding agreements under which payments out have been made, whether you're looking at current funding agreements in relation to extant proceedings, or whether you're looking at future funding agreements. And I think, you know, funders have been considering a range of different responses in relation to each of those situations. My own personal sort of perception is that the number of situations in which a real problem has crystallized are still relatively small. Mostly, I think we've found stakeholders taking a pragmatic approach, but there's no doubt that of two things. Firstly, that it does incrementally add to a risk profile analysis for a funder in some situations. And secondly, there are undoubtedly going to be cases that where defendants in particular see this as an opportunity to create some leverage and from a funder's perspective, we would say mischief.
Yeah, and Elena, how would you take that?
Yes, just to echo probably in the same way that we have seen that funders have been preparing for this decision. And when the decision was announced, we have already been working with the parties to amend the documents. Again, we haven't seen much panic. There were certain approaches that we can discuss maybe later that were worked out by the parties. We have not seen many disputes as well, and the parties, when faced with a request to make changes to the documents, were happy to proceed on that basis. I think we've been working on one case where there was a dispute with respect to an issue caused by PACCAR. And it's interesting to see how it sort of pans out and how the argument about the decision are raised. But so far, this is the only out of many, many transactions that we have seen since summer in respect of the decision.
I mean, PACCAR is interesting from my perspective because it has had an effect to one certainly relevant for me, in that we've delayed our next fund launch to allow for the PACCAR decision to come out, to make sure that our documents are going to be compliant and so on. But it also raises something I think that happens in funding in particular, that specific issues come out of the woodwork in funding in a way that they don't in other areas, and suddenly something that was complicated becomes even more complicated, and group actions are one of those things that really do throw that out specifically. And Philip, just comment about that from your perspective as to how you found these sort of issues coming out of the woodwork.
Well, I can't really talk about specific investments, and my focus is more on continental Europe, but I would say that so we've always taken the view that as a policy and legal matter, the DBA regs should not really apply to legal finance, but we were alive to the risk like other players in the market. And we essentially structured our affairs in such a way that it would withstand the feared onslaught. So we've done that, and I know anecdotally that other funders, as we hear from Richard and Elena, are also pragmatically addressing it.
Yeah. No, I mean, I don't think we need to go much more with you in relation. I understand that it's an issue that everybody has to deal with differently. As an example of PACCAR, just for the audience that you don't know what it really was signifying, the idea that all the things that you've funded up to date could suddenly be ripped away from you at the last minute is a sort of funder's nightmare, that a decision comes out that you're not expecting. And as I said a moment ago, from a collective action perspective, there are a lot of things in collective actions that make funding decisions quite difficult. I described it as a sort of the funder's appetite for a curate's egg in our discussions internally. And looking back when I started 10 years ago, there were 2 or 3 cases that I started with that are still going on at the moment. And one of them has been up and down to the Supreme Court a couple of times already. So, Philip, how do you find that the time factor of group actions is a relevant criteria for you when considering whether those cases are good cases to invest in?
Time is very important. I suppose as an investor, you need to protect yourself against duration. You can do that in a number of ways. But that is absolutely critical, especially in the UK collective redress space, obviously. But equally as important, maybe, especially in English courts, is the adverse costs challenge. That is, to my mind, a hugely significant challenge for anyone looking at this as an investment. That is, in fact, one of the reasons that at Burford we've established our own adverse cost insurer called Burford Worldwide Insurance Limited, BWIL, that is able to insure Burford's investments. And that helps with economics and, in a way, also protects you against duration, actually.
Yeah, Robert was saying earlier on about the astronomical budgets and people who hadn't thought about it. My experience is that they have thought about it, and they're still astronomical. Elena, do you find that people are coming to you and wanting to try and structure agreements with duration in mind as a significant risk for group cases?
Yes, absolutely. And what we do as part of our practice, we also connect cases to funders, and before we do that, we analyze parameters of the case, including budget, including risks, whether it's enforcement risk or duration. And a lot of times, it's interesting that we still have to flag those important elements and then help the party bringing the claim to try to mitigate it, to see what we can do, look at insurance before we actually show it to the funder and saying, well, this is the risk and these are our proposed solution. So absolutely, yes, this still remains one of the main factors to consider for both the claimants and the funder.
And my take, Richard, is that funders are going to be looking at ways of dealing with, not just with risk, but of longevity, but of other aspects as well. How do you see that?
Yes, I think the duration issue, and you're absolutely right to sort of mention some of these cases which I think have lasted a lot longer already than most people's worst case scenario might have been, and that the industry has learned a lot from that. And there are at least two things that I've seen in our discussions with our funder clients. One is the introduction, a move away in the structuring of funding agreements from a straight multiple of capital invested model to a return model which is more IRR or MOIC based. And obviously that's one way structurally to mitigate duration risk or accommodate duration risk. Another possibility, maybe it's a slightly separate topic we may come on to, but another way I've seen duration issues manifest is in a growth of a secondary market and funders looking to monetize or off-sell interest in, or sometimes even entirety of claims. And part of that is undoubtedly connected with duration risk. It may be as simple as the fact that the case has gone on for longer than anticipated. Investors are hungry for a return. They're looking for ways to keep investors happy. It may be, and we see this, and we can comment as well, of course, it may be as well that the funding entity was itself a fund with a sort of constitutionally hard-baked lifespan, and as that fund is reaching its kind of end of life, there may be sort of one or two residual investments left in there which have continued for longer than anticipated. And again, that's another driver for a kind of secondary market. So certainly from my perspective, I've seen at least those two ways that funders have been dealing with the duration issue. And
maybe another interesting trend is also funding the law firm, and that way diversifying your risk and getting, for the funder, to getting paid from sort of first available cases that settle or what.
And that's certainly a way that a lot of people are approaching the PACCAR issue, because funding through the law firm is an area that means that you don't necessarily have the same problems. I think the difficulty that funders have had over the period in the UK and in Germany and in the Netherlands as well is, to an extent, they have been responsible for the growth of the class action market. And certainly in some jurisdictions, I mean in the CAT in particular, I don't think it's really practical to bring a case in the CAT without funding now. And so, of course, as soon as you have a problem and a defendant tries to exploit it to their benefit, you're going to have test cases, appeals, and we've seen the growth pains of that over the last 10 years. And the question, I suppose, for you all, and Philip, why don't we start with you, is are we going to see it in the next 10 years with further growth pains, or do you think we're out of the woods in the UK? And what about how the other jurisdictions that you're working with compare? I mean, certainly my experience of Germany, for example, has not been great in terms of speed.
I think in reality, wherever you pursue your collective matter, you will face very, very subtle difficulties around a number of issues, structuring, adverse costs. It depends on the jurisdiction, and now we have PACCAR here. I would say this, I suppose, but sometimes it is worth considering pivoting to a continental European jurisdiction. It need not be Germany, it could be the Netherlands, or indeed other continental systems. Where this is going in the UK is very hard to say, to my mind. I am much more bullish about the continent. Actually, it depends on the particular matter, but I think there are very attractive ways of getting things off the ground, and it doesn't have to be an opt-out structure, right? In Germany, we'll never see opt-out in a true way, I don't think. It's just not going to happen, but that's fine. There are other ways of dealing with it. The flip side of that is structuring. You have to be very careful about that. And of course, just like here, you need patience, duration protection, that sort of thing.
Yeah, I think that in a way, all jurisdictions are catching up with the litigation that's coming at them, aren't they? I mean, I remember in the Danske litigation, the whole case had to be stopped because the judge fell off a bike going to the courtroom, and there were 3 or 4 cases all, waiting to be heard. And the system just wasn't geared up for thousands of people. I know that in Denmark and Germany.
That is a significant drawback too, by the way, in continental Europe. The extent to which first instance courts are quite overburdened with their caseload. That applies in a number of jurisdictions. That's a very significant factor.
I mean, it applies very significantly in the CAT. I mean, it's one of the biggest problems for funding now is that well, if you're going to start a case, you're not going to get a case management conference for a year, and the funding budget is therefore going to have to be elongated. I mean, and this is the structuring, I suppose, that we have to concern ourselves with. What about defendants not having to take too many difficult points because of the way that the claimants have put their claims together are difficultly pled or are wholly, and so little issues have been peeled off by defendants? How have you seen that play out, Richard?
So, well, I mean, from my own perspective, so firstly, on your previous question, I think I'd probably go further. I mean, I am probably a little bearish, and I think there are, whether it's 10 years, I think there are some more growing pains for the UK and for continental Europe. I mean, Europe, we heard on the last panel, I mean, the legislative regime is even newer, there than it is in the UK. And I think in the UK, PACCAR alone, I think, is going to throw up more issues, and we're yet to see how it's going to play out properly in the CAT. So I do think there's a few more years, and I think, Philip can talk, and Jeremy, you can, obviously, about how that's seen in the overall kind of risk analysis by funders. But my own sense is that, it's not a risk-free investment strategy in any event. There are always risks. The most obvious one is losing the case. This is just another risk which may extend out, may cause some roadblocks that need to be overcome. But I suspect we will. I suspect it will keep Eleanor and I busy for a little bit longer before it's properly worked out.
That's certain.
Yes, yeah, exactly. I think in terms of the defendants, I think the classic, my own perspective is that, the defendants in these cases are typically very large, very sophisticated, very well resourced litigants. And a lot of them are battle hardened from experience in the US already. A lot of them have actually significantly more experience in litigating class actions than the plaintiffs who are bringing the claims against them. And they are skilled, as you would expect. They're extremely well advised, and they are skilled in spotting sensitivities and points of pressure for claimants, and that may be just playing the long game and stringing it out, blowing up budgets, those kind of things. It may be, there was, I think Mr. Justice Waxman talked about disclosure, obviously as being a point of contention, not uniquely in collective actions, but in proceedings, more generally in this jurisdiction and in the US, less so in continental Europe. But that is, defendants see that may be in certain cases, securities mis-selling being a prime example, a point of sensitivity for plaintiffs. And they're also, as you say, well able forensically to attack points of pleading and just get little wins along the way in interlocutory hearings, which has the effect of stringing out the proceedings and then reducing the overall impact. And obviously in the Merrick's case, for example, we've seen a huge number of points being taken in relation to the universe of the plaintiff class in that case. And not all of them, let's be clear, but by no means have the defendants succeeded in all of those arguments, but they have succeeded in some, and in respect of each of them, it's added another X months to the process.
Yeah, and Philip, do you see that as being litigating against the funder as against the claimant, effectively, in the sense of everybody appreciates how important the funders are?
Yeah, that is often attempted. I suppose I would say it's normally mainly a way of just stringing it out and diverting attention from the substance of what is almost certainly a meritorious claim, otherwise it wouldn't be backed.
But we have seen probably very few cases where the funder would actually stop funding the case because of the sort of the challenges that were brought by the defendant. I think most funders, or most established funders, would do their due diligence before the case, and they would expect most of the sort of challenges that would be brought by the defendant. As I said, I think very few cases that we have seen would have stopped because the funder decided, that's too much, I don't have enough money and I can't syndicate.
Yeah. And
that.
so, Philip, if you were sitting in front of your ideal collective action, what would it look like?
It would, well, first of all, I suppose you would want a very healthy and large book of injured parties that is well organized, and you'd probably be working with some kind of claims aggregator or legal services firm that is really good at this and has a very good relationship with you and the injured parties, possibly through trade bodies. You'd have an excellent claim. If you were here, you'd have very, very robust adverse costs protection with a healthy buffer. The economics of the whole claim would need to bear your healthy budget, and you'd need excellent, very good law firm. We all have our good relationships with the right sort of law firms. And in England, you'd want a cracking counsel team. That is a tall order. You almost don't get all of that in a normal case. I tend to think it's often a little bit easier in Europe. You don't need barristers. Adverse costs are much more manageable, although not entirely insignificant, depending on your exact forum.
The trouble is, with that description that you've given, what you would normally find is that you get two funders and two claimants coming out because everybody thinks the same. Ellen, have you seen that in practice as to how funders are cooperating and non-cooperating? And we talked about it in the previous panel about cooperation, and it is clearly one of those things that is crying out, and it's obviously happening very recently in the CAT. Have you seen it in practice?
I think we've definitely seen a trend of funders being more open to co-funding and partnering and syndicating and sharing the risk. And on the law firm side, just maybe to flag, so what we are seeing is law firms that are very good at book building and identifying opportunities. They sort of sometimes try to go too fast and prepare market launch the claim before maybe it's legally all thought through and properly, and the funder had properly time to due diligence the claim and all the commercial and legal parameters with the law firm. And obviously the funders are competing against each other to be sort of the most, the fastest to respond and be most efficient in this process. And sometimes this may lead to a claim that hasn't done all the, sort of hasn't gone through all the tests to make sure it's sort of properly ready to be launched against a sophisticated defendant.
Yeah, Richard, you'd say the same, presumably, that you've seen cooperation in some respects.
We have, and I think that's certainly a trend, a fairly recent trend, and one that I think I would expect to continue is, as Elena says, the kind of co-investment. I think there's a sense. My sense from discussing with some funders is there is a sort of growing sense of kind of a concentration risk issue from their perspective, and one of the things that has made people more inclined to think about, along with the kind of ticket size, which is continued to grow sort of year on year, has encouraged people to work together now, which I think is an interesting. It throws up some new challenges, but it's an interesting development.
Yeah. And so, Philip, from your perspective, in terms of the opt-in or the opt-out nature of actions, both here and in overseas, in Europe, have you seen any indication that opt-out jurisdictions, apart from the CAT, is something that is really taking traction?
Yeah, you're really beginning to see certainly more opt-out actions being floated as ideas in continental Europe, and there's certainly a big uptick in inquiries at Burford. I still see continental opt-outs as in the early phase, at least for Burford. I'll probably speak for other funders too. It's enormously interesting by its very nature. I do think one has to tread incredibly carefully because it's just an entirely different beast. And the good thing is that at the same time there are very viable opt-in structures in most notable continental jurisdictions that are perfectly feasible and continue as we speak. But having said that, it's obviously exciting, and that there is real potential. It'll be interesting to see which European jurisdiction really cracks this nut. Maybe it's the Netherlands, I don't know. It'll be very interesting to see.
One of the contentious remarks that was made in the Supreme Court in the Google case was that the funders are essentially driving these claims forward, and it's for their benefit rather than anybody else's. Obviously, that was a subject that was rather hotly debated at the time. With that said, what is the explanation in your mind for why it is the fact that over the last 5-10 years there have been such a great deal of more interest in group actions, whereas they've been going on, the structures have been in place, the GLO has been in place for a very long period of time. It's only really in the last 10 years. Why is that?
I think it just shows the maturity of the litigation funding market, and to a certain extent, if you look at the leverage of corporate finance market 20 years ago, in early 20s, in early 2000, when it was predominantly led by banks, and then at some point, all the private equity funds came in, and they created, more complex structures, mezzanine debt, pref debt, and this sort of allowed different borrowers and developers and sponsors to finance different structures. And I think the same is happening with the litigation funding market. And I think it's a good trend to have this variety of funders who are coming in that are interested in different asset classes, in IP litigation in Spain, in different products. And this allows participants in the market to bring the claims that they may not, cryptocurrency, that they're not able to bring otherwise. And again, I'm a big believer in the fact that funders would only fund claims that, that have great merits, and that's just a really efficient way and robust way of bringing them to the market.
I'd agree with all of that. I tend to see this sort of visually as something of a kind of Venn diagram, where I think there are a number of sort of symbiotic trends, macro trends that all sort of work together. So, you've got all of the kind of financial economic drivers that Elena was mentioning. I'd add to that a kind of, until recently, a persistent low yield macroeconomic environment has made litigation funding a more interesting investment proposition for people. I think you've got the fact that, collective actions, which is what you were asking about specifically, Jeremy, I think, those are claims which just sort of lean hard into the kind of ESG trends or drivers that are coming right up the kind of corporate agenda. I mean, those E and S and G type claims, whether they are environmental claims, whether they are securities mis-selling claims, whichever they might be, are naturally ones which fall to be litigated as collective actions in one sort or another. You've got data privacy, which obviously is another whole sort of subset of collective actions, and which again, naturally lends towards that. You've got legislative, you've got maybe another overlapping circle is legislative support across Europe. We've got the directive, for example, and other jurisdictions sort of further afield as well. By and large, I think you've got judicial support as well. I mean, certainly, particularly within the CAT, I think there have been a number of helpful, supportive decisions which have clarified or de-risked this in some respects, and it's not all one-way traffic as we were talking about earlier, but you've got a number of kind of supportive comments like that. So I think there are all of these different types of kind of trends which and litigation funding is one of those, I think, and they all, to my mind at least, and as I say, not without roadblocks and diversions, but they all work together with each other to support and encourage a growth of class actions.
Yeah, and in terms of the split between 5 years ago, if we were having this conversation, we'd have been probably talking about securities litigation being in the fore. Now we're talking about the CAT. Is that because, Philip, in your experience, the securities space has not been as successful for funders as we thought it would be, and the CAT is now the in thing because everybody has to go to the CAT to be funded? Or is it, how do you see the allocation?
There are different ways of looking at this, obviously. We find securities claims tremendously interesting, and we continue to do so. We'd like to see more of them.
Yes. So would Trip.
To the extent they're good ones. So I wouldn't think too much by way of categories. It's the key thing is to have a really good claim and to enable an injured party, whether it's an investor or a consumer or a small business person, to obtain redress for what is a good claim, a type of redress that is absolutely impossible for them to obtain in any way without someone else leveling the playing field.
And that leads us directly to the consumer, doesn't it, in the sense of one of the rises of collective redress in the last decade has been because of the focus on the consumer. One of the benefits of the EU has been clearly that focus. Is that something that any of you have seen in terms of the management of claims? Because one of the problems, certainly in the RBS days, let's go back to that, when a group of people tried to manage a securities case without really any professional support, and there was a lot of unpicking of that, and essentially part of the failures of some of all that was because of admin and back office. That's obviously moved tremendously over the last few years. I mean, how have you seen, Elena, that sort of, or have you seen any kind of focus on the management of claims?
It's probably not a question to me because I'm on the finance side, and our litigation team would be better placed to deal with this. What we are seeing sort of in my practice is when we assess whether funders assess whether to fund particular claim, they don't just study merits, etc. We do study those management systems, how they work, and obviously on mass claims, you cannot look through every claim, but we look through how the management system worked on the previous claim, whether it was successful, what are the tools, how the process works. So this is what we sort of study, part of the due diligence.
And Philip, from your perspective, it clearly is a factor that you're going to be looking at carefully as to how the claims are actually run and managed from an internal perspective.
That's crucial. And you cannot overemphasize how different, at least in my experience, every single class action or collective matter is, even within the same jurisdiction, the same courts. Each one is different. And the way it's set up and the way the claims are managed and the way the interactions with the injured parties are organized, that's absolutely vital.
And you want to be involved, well, certainly from my perspective too. A funder wants to be involved at the beginning. The worst possible situation is for this system to be set up without regard to the funder's view. Not that that's a controlling issue, that's more just a sort of sensible, common sense application.
And the claimant's view, and to make sure that you have appropriate data, that the claimants, in fact, do have a claim that they think they have or have been told they have, that sort of thing. That's essential. And it's an enormous logistical endeavor. It's an investment proposition in itself, in fact.
Yeah, I mean, I don't think one can over-exaggerate the amount of administrative burden that these group claims bring upon funders and upon every aspect of the stakeholder chain. And therefore, the interest, from my perspective, is quite how they have grown so significantly over the last decade, knowing that it is a huge investment for everybody. And that's why I think it's a juggernaut that started and is going to continue. And clearly the EU's representative director is going to assist on that.
And I think as well, Jeremy, sorry, I mean, you only need to look around this room to see the kind of the level of the US service provider ecosystem and the scaffolding that supports these claims from kind of cradle to grave in the US to that has grown up and is now like a super sophisticated system for dealing with the admin, whether it's the book build admin, whether it's the payments at the other end admin, whether it's the corporate governance in the currency, during the currency of the case. And I think, we've still got a lot to learn from our colleagues in the US in that respect. And I think we've been able to benefit enormously from the importation of some of that expertise to help manage these issues. So, again, we haven't been trying to figure it out for the first time. I think certainly my own eyes travel both the kind of litigation and the finance side, and I think on the litigation side, we have seen the sophistication in relation to the corporate governance elements of these agreements transform quite significantly over the last few years. Interesting. It is an aspect which has perhaps been subject currently to less sort of judicial scrutiny than some other aspects of these arrangements. The economic aspects of the arrangements have attracted almost all of the attention so far. And maybe that's and hopefully that's a sign that the systems in place, are working well.
I think it's also a function, unfortunately, of the time and the cycle that we're in. We haven't got to the point, unfortunately, with some of the conversations that are going on today. We'd want them to be happening, but we haven't reached it. I just was going to ask anybody in the audience whether you've got any questions. I mean, I'm sure there are some microphones if anybody's got any questions. I don't know how that's done. But if you do have any issues that we haven't kind of covered, and you'd like to, I mean, this is normally the time where everybody's phone starts ringing and people start looking at other things. But if there is anything anybody's got as a question, I'd be very happy to get one of the panelists to answer it. Yes, please, go ahead. You might have to shout. Oh no, I think there's a microphone on its way.
Just as a recap, what are some of the most prominent challenges in synergy between funders and litigators when it comes to the relationship? And you talked about the screening process and building a good kind of dynamic, but what are some of the hurdles you've come across when it comes to the very complicated process of cooperating and working together in a case?
Yes, I got some of that. I have to confess I didn't get all of it. I think the question, I'll rephrase it if I'm right, was more about relationships and about the interaction between the parties. Is that's fair, and how you balance that? Philip, do you want to start with how you deal with the relationship side. It is a crucial point that you raise about the importance of a relationship between all the parties and the trust and confidence that there is.
I thought, was it between the claimants and the claimants' lawyers, or all the parties?
Sorry, between the funders and the lawyers doing the case.
And the claimants' lawyers?
Yeah.
Yes.
Yeah, that's a critical relationship that for any successful funder will have very deep relationships with law firms. And there'll be ideally a year-long standing relationship, and it's a two-way street.
I mean, if you're asking about sort of points of friction that can sometimes arise, I would have thought the preeminent example has to be budget, right? I mean, that's just a constant feature of discussions. I mean, funders will consistently say they can't believe how much you think it's going to cost, and then they will consistently say that they can't believe you've now exceeded your already exorbitant budget. So I think, but I think, now actually what we find, with the funders that we work with, is that they now have this phenomenal bank of data, which actually typically far exceeds the data that the claimants' lawyers themselves will have about duration and about costs. So we've now found that we can learn a lot actually from our litigation funding partners in terms of where costs are really likely to be incurred and how much is likely to be. So I'm positive about it in the sense that I think it is finding a balance. But I think it's certainly sort of leading up to now, that's certainly been what...
My observation, Richard, is that it often, from a funding relationship with a law firm, it's about the transparency and the trust that you get right at the very beginning in terms of the going backwards and forwards. And often, from a funder's perspective, at what stage you ask the law firm to get involved and how they present to you in terms of the goodwill that has to exist between the two. And I've often found that a law firm dealing with a funder, often there comes a point in a case where the goodwill is needed again from the law firm. And if the funder hasn't treated the law firm well at the beginning, the law firm is a lot less able to help. And it's that difficult point where the case could come unstuck. And that's where defendant senses that. And that's where often problems arise. But it's, from my perspective, a transparency issue from the very start and just a relationship exercise.
And also, I guess, interesting how it would go as a relationship lending if we talk about law firm funding as a way of funding class actions, and whether law firms would be sort of growing more towards the model of, one funder as a core funder funding one law firm, as we've seen maybe with PGMBM recent transaction, which was $500 million law firm funding, or whether law firms would continue to seek different funders for each of those cases to see, which funder is better suited for a specific case. And maybe that would be different for, each law firm.
Any other questions? With 1 minute, 30 seconds to go. It's got to be pretty rapid fire answers from the panel. But if there's any question about, favourite moments, anything. Otherwise, we'll probably draw it to a close. But if there is any other questions out there, now is your chance. Oh, yes, please.
Hi, thank you. One of the panel members mentioned that they would look at cases, particularly where redress is absolutely impossible for them to obtain in any other way. How does that pose a challenge, if at all, with the fact that funders only want to fund claims with good merits, particularly in the light of the comment about access to justice?
I'm finding the audio quite difficult to follow. I think if you might get more if you just ask the question without the audio, actually. Or maybe we do need it. We heard the second half, I think, but I didn't hear the first half.
The first bit, the crucial bit, I didn't catch.
I'm so sorry about that. I'll try again. So you mentioned that redress, you'd look at cases to fund where redress is absolutely impossible to obtain in any other way. Does that pose a challenge for funders where you only look to fund claims with good merits, particularly in light of the comment about access to justice?
Okay, so yeah, in terms of how do we resolve the inconsistency between a case that, you know, needs to be brought, but a case whose merits are not necessarily adequate, and how is it access to justice if you just ignore all those cases?
Well, certainly at Burford, the idea is that you fund meritorious claims where the injured party or the claimant is either unable to pursue it economically, or indeed, this is not so much for collective actions, or indeed is unwilling to use their operating capital for it and want to use external capital. That's a huge trend, but it's not for this conference. But the idea with collective redresses is simply that what I meant was that you see these whole bodies of industry that have wonderful claims, legally speaking, highly meritorious claims, that those can be facilitated by leveling the playing field between them as a group and the group of defendants. And to the extent the claim is not meritorious, it shouldn't go through it wouldn't pass the diligence process. That's the idea.
Yes.
Because we wouldn't fund it if we thought it was a bad claim. And I think we'd ultimately lose.
Yeah, no, well, exactly. So, but I think, I don't know whether it's part of an answer to the question, but there is a sort of subset of claims where they are historically have been caught in a sort of trap where they don't have the money to work up the claim to a position in which it could be considered to be investable. So they don't have the cash to do that, but because they can't get it to a position where it's investable, they can't get the cash. And so there definitely are some access to justice issues there in relation to some types of claims. And there we have seen a response with this sort of the fairly recent growth of the kind of seed capital kind of funding in the litigation context, where there are now players coming into the market who are prepared to finance finance the process of actually diligencing and working up a claim, and that I think is a route to access to justice for some of those meritorious claims that hadn't previously been able to tap the market and proceed.
Yeah, that's a good point.
Yeah. Well, I think we're going to be kicked off now.
Says time is up.
Time's up. We're going to be shooted off the stage. Thank you all very much for your contribution.
Thank you.